Good morning, everyone. Thanks for coming to this residential form changes seminar Zoom call. We have John Waite with Martin Gifford law firm that's going to go over some of these forms today for us. And hopefully you will find it informative. So on to you, John.
All right, sounds good. Thank you very much. Appreciate that, Steve. My name is John Waite. I'm with the law firm Martin Gifford in Winston-Salem. Our firm is general counsel to the North Carolina Association of Realtors. So that's how I ended up here today. We do a bulk of their legal work. One of the things that my partner Will Martin does is works on the forms committee. All our forms are done through that committee, the joint forms anyway. The joint forms are done with the committee that also meets with lawyers from the North Carolina Bar Association. And there's yet another subset of that committee that works on the forms that are not joint forms. But today we'll be going through the forms changes that just came out July 1st. And one of the important things to know about the forms changes is that you get a grace period of 60 days. So, you know, if you want to use the old forms, you can. We don't recommend it, especially because a bulk of the changes this year, I think in previous years, I would say for the past 2 or 3 years, most of the changes to Form 2T have been largely cosmetic and not substantial. That is not the case this year. So I think based on what the changes are, you're really going to want to consider moving to the new form as soon as possible and not using the grace period. But if you do, use the grace period, then you're certainly allowed to do that under the North Carolina NC Realtors forms policy, which there is a forms policy. And just as a side note, one of those policies is that you can't just take our forms and give blank copies to clients or to friends and neighbors. Okay, that is not a permissible use of the form. So you have to, if you're going to assist someone like that, make sure you're actually filling in some of the material so you're not violating the policy. And also another thing that weirdly has come up a couple of times, one of the things we do for the realtors is operate the legal hotline. So if you have any questions following up today that we don't get to, don't worry about it. You can call us on the legal hotline, and that phone number is 336-294-1415, and that's 336-294-1415. And also you can email us at legalhotline@ncrealtors.org. So you can use those two things, and we get back to people about probably 95% of the time we get back to people same day. I would say 99, but I don't know what my other two Bozo partners do. For me, it's about 99% of the time I get back to people, but they're a couple slackers, so I don't know if they keep up with me or not as far as that goes. In any event, so on the legal hotline, we've been getting questions about whether agents who are not realtors anymore, brokers, being able to, I guess, pay another firm a fee or something like that in order to be able to use our forms. And so I don't really know who decided that would be a good idea, but that is not a good idea. That will get you a cease and desist letter from my office, and we are not very nice about them. And we're very serious when we send them. So make sure that if you're not familiar with the forms policy, or if you have a question about it, you can find it on the website, or you can email us on the hotline and we'll send you a copy of it. But on the whole, not too much drama goes along with that, but you do need to know that it's out there. So let's go ahead and do it. We're going to spend hopefully no more than 30 minutes, and I hope as close to 20 minutes as possible going over the major forms highlights. And just give me a moment here while I share my screen. I got to get this thing out of the way. It just gets too... Steve's head is distracting me. Okay. So everyone should be able to see my screen. If you can't, unmute yourself and yell or whatever. But this is our website, ncrealtors.org, okay? And what you want to do initially is log in. There will be a login key in the upper right over here. Click that, log in. If you have issues with login, call the hotline number I just gave you is the main office in Greensboro. So you just call them and tell them, hey, I'm having a problem logging in the website. They will hook you up with somebody to help you log in, okay? Once you do log in, there's these buttons up here. And this one here is forms and contracts, okay? And that's where I'm at right now. Q&As are also here. So if you want to see our Q&As, I mean, they're all, in this arena. And actually that's where we are today. Forms, if you click on that button, it'll take me there. These are where all the forms are. So if you want to see the contract forms the way they are, and these are all the updated forms. So July 1st, the ones that just came out a few days ago, they are all uploaded here. If you have an emergency and you need, one of these forms and you can't get it through whatever third-party provider you have, you can always come get them here. But with respect to going through what we're doing today, we'll be in the Q&As because all these Q&As have lots of different topics, okay? The Q&As come out every week. So there's a lot of different things in here. One of the categories for Q&As is forms. And this one here, I mean, under offer to purchase and contract, every single one of these folders is full of just all sorts of stuff, okay? But what we want is right here. And sometimes we get questions about forms changes in the past. And as you can see, we've got forms changes that go all the way back to 2017. So if you really want to see what's different about a form from then till now, you can totally see it that way. And what we're going through today is the 2021 residential forms changes. And you can see that's right here. But if you want to know commercial's right here too. And also, some came out in May last year. That was a special category. So those are right there. And eventually the property will do a property management one too, if there were substantial changes in there. I'm not sure on that. I have to ask Will. I don't serve on the committee, so I don't know where they're at with that. But I would presume that there would be at least some property management forms changes. So I would expect that to be uploaded pretty soon. If you were to click on this here, okay, which I'm not going to because I already did, and it's right here. This PDF will come up in your browser. And we do this we do this every single year. So it's if you want to know how to navigate this in the future, I expect it'll be the same. Although we are planning on revamping the NC Realtors website. And so some of the things might be moved around a little bit, but I would expect the functionality to be substantially the same. If you've ever done a website update, things generally stay the same. So it starts off, this PDF is it gives a summary of all the forms changes that have happened. And so you have right here, offer to purchase a contract. These are the joint forms that I talked about. These are between NC Realtors and the Bar Association. And then you also have like the listing agreement that is just an NCAR form. And if you go down, and this is the start of the Bar Association, you can see these hyperlinks right here. And you can click on those. And that will take you to not just the form, but it shows you exactly what has been changed with yellow highlighting, okay? And in this case, you can see a large part has been crossed out. So let's go ahead and start with that. And if you want to take a minute and navigate to this, you certainly can. So, just once again, ncrealtors.org, log in, Q&A, go down to forms, and then click on this right here. And then you'll be right with me in this document. And if you want to click on this, then you'll be right here over in the offer to purchase. So let's go through these changes because there are quite a few of them. And this is probably where we're going to spend the bulk of the time today. I'm going to try to still keep it kind of highlight level, but really at least make sure I hit the important points. As probably most of you know, one of the big changes is that now you have this new checkbox for electronic transfer. And one of the questions that we've been getting, including Steve asked me about this last week, I think, is, what about big due diligence fees? It's been beat into your heads for so many years. Don't share wiring instructions, and the wiring instruction fraud warning is still in here. But the way the committee came about, this particular thing is, number one, you don't really have an option. Like, you have to make this happen. You have to figure out how to make this work. This is simply the future of the industry. So trying to leave this out or avoid it, it was unworkable at this point. Too many people are asking for this kind of thing for the due diligence fee. And so we want to try and make sure that the forms keep up with where the actual industry is at. So internally in your office, you're going to need to come up with some policies, and it'll really be up to firms and agents to come up with things and how to deal with this, because the risk of an error occurring with this is the same as it is with any other money transfer. So you're going to want to take it seriously, and you're going to want to have a policy in place that reflects it. You will need to work with, probably your own lawyer, or if you don't have one, go get one to help you with your policy manual, because we don't give that kind of specific advice on the hotline. So it's not like you can send us your policy manual and walk through it. But what a suggestion I would make is, as a firm, figure out what is a large due diligence fee. For some firms, that might be, anything over $1,000. If you're a small outfit, that could be a big due diligence fee. Even though I know in the grand scheme of things, that is not right now in some markets. But you have to make that decision internally, because you really got to say, all right, if everything gets blown up, what am I willing to cover out of my own pocket? So for some people, that could be $1,000, right? For other big firms, maybe it's $5,000. Who knows? But in any event, figure out what that number is. And then if your client is making a due diligence payment that is over and above that amount, you're just not going to handle any of the information with the electronic transfer. You're just not going to do it. As a firm, that's your policy, that you're just not going to touch those. So that's just one way to address it. Another way to address it would be, even though the forms committee didn't do this, I think if I was an agent, or a firm, I would create an internal addendum to the contract for electronic transfers of due diligence fees, and make the seller fill that out as part of the returned accepted offer. So you got it right there. I think that would probably keep down and limit the exposure that you have. But I would say that setting that dollar amount as far as what you're comfortable with is going to be crucial, because if the client's over that, just for me personally, I could think if a due diligence fee was $5,000, then I would strongly recommend to the client that instead of doing an electronic transfer, go ahead and just make it a check, and don't mess around, and make sure that check gets to the seller. But that's my 2 cents. There's a lot of different ways to solve that issue, but it's not really something you can avoid. So you're just gonna have to tackle it and then go for it. The form provides that so that people can do what they need to do in the transaction. And just remember that you do have this mechanism that's always been here. But if you don't get the due diligence fee paid within 1 banking day from the notice to deliver cash, and we have a form for that, Form 355, you can make that demand for the money if the buyer doesn't pay on time. And that's a handy dandy form, because you don't have to invent something or make sure you get all the correct language in an email. You can just fire off the form and it'll do it for you. But if you need some wiggle room, then it's there with 1 banking day. Obviously some sellers are more reasonable than others when it comes to that delay, but in any event, just so you know and be reminded that it's there. The first edit here is kind of a technical one, but it's one meant to strengthen what we believe already was the rule in the old form. And that is that if the buyer fails to pay the due diligence fee, then the seller should be entitled to both the due diligence fee and the earnest money deposit for the breach. So we're going to get more into that into new paragraph 23, where a lot of these different things were moved. And another thing that's in that paragraph is attorney's fees. So just be aware of that. All right. And you can see the same thing here. A lot of this is going to be simplified and moved down to paragraph 23. So just to understand, earnest money deposit has been changed. That paragraph has been changed. Paragraph 23, we'll get to that in a bit. Okay. So here's the next probably big change in this form, I think. And the reason for that, it may seem sort of innocuous for firms who are doing this correctly in the first place. However, I will tell you that based on calls from the hotline, this was one of the most consistently screwed up sections of the offer when agents filled it out. So what you could see is what the Forms Committee started with here, and we're going to get more into this. Well, actually, I think I'll just go directly to it and then circle back. But you can see proposed special assessments, confirmed special assessments, all that stuff has been struck. And the reason is because of this. It's this section down here. And what many agents did was, when buyers would fill this form out under the seller representations, which mind you, this title here is self-explanatory. This is seller representations, okay? It's not meant to be a legal obligation. It's just representations. It's informational so that the buyer knows. But of course, what agents would do, buyer agents would do is in this blank here, put something to the effect of none known if any seller to pay, none known if any seller to pay. Well, that completely altered and made ambiguous the otherwise clear obligations of the parties, which is the seller paid confirmed ones, those that would be payable or due prior to settlement, and the buyer's obligations to take to anything that was being considered, but it hadn't been approved yet. So, anyway, agents were doing that very consistently. So now what we have here is that sellers shall pay special assessments that are approved prior to settlement, and then taking away all this stuff. And similar with the buyer. I think I may have skipped past that already. So let's go back up here. There we go. So just a moment. Yeah. So in this paragraph here, it really puts the onus on the buyer to look into special assessments that are under consideration as part of their due diligence. So it really kind of takes the pressure off the seller. Now, granted, if there's something big going on, I think it could still follow under material fact, technically speaking. So I do think that if you are aware, if the seller is aware of something, and I think if you're the listing agent, you're going to want to, do that as part of your check-in. But it's putting more burden on the buyer to look into that prior to settlement. Okay, and it could be as simple as the buyer just asking that to the seller. Sellers still have to go, figure out what's going on. And sorry for the scrolling there, but I was looking for this, and this paragraph has been changed too, so that any assessments that are approved following settlement, it's going to be on the buyer. Okay, and what we hope is that agents will quit screwing around and inserting that language, since we've removed the blank, and that those obligations will remain how they are, unless the parties want to do like some kind of amendment to the contract to alter those obligations, which is certainly possible. But generally speaking, most transactions, that's going to be the way to do it. And the reason is not because the Forms Committee wants to force that down people's throats. It's really for the protection of both the buyer and the seller. And maybe maybe more the seller. Because if you don't do that, and I've actually had litigation cases about this because our firm does other things other than just, NC Realtors work. We represent agents who are, facing discipline in the commission and things like that. And one of the things that we do is we get involved with lawsuits, a lot of them real estate related. And I tell you that I've been in several where the agent has inserted that language that I just talked about, none known, but if any seller to pay in that paragraph. Well, then lo and behold, there is something, and it's being proposed, but now it's a proposed special assessment that maybe wasn't being I mean, you know how HOAs are. They may or may not be getting into a serious discussion about it or not. It's hard to tell. These people are nuts. These people who are willing to be on these boards are just not, these are not normal people. And I say that as president of the HOA of one of my rental houses. I mean, dealing with these people is just very, very, anyway, whatever. I won't go into that, but you know what I'm talking about. HOAs be crazy like crazy. And so who knows what they are or are not considering at any given time. And so if you write that language in there, well, now the seller, you could argue that the seller has to pay proposed, special assessments, but how far into the future? No one knows. And then you're just asking for a lawsuit. So, and not just a lawsuit that involves the parties, but pretty good chance agents are going to get dragged into it if they insert a language in the contract that weren't supposed to. So that's a really long-winded way of saying this is this way for a reason. And I know agents sometimes get frustrated that blanks get removed from the contract, but quite frankly, it is because agents consistently abuse it, even though we tell them not to. So then we have to try and make sure that we do something that is workable, but also protects agents and their clients as much as possible within reason. All right, small technical change here. That we bounced around much, but that is special assessments, and you can kind of adjust that more later. This here, it's a little change, but it's also kind of a big change. If present on the property on the date of the offer. So if these things are not there on the date of the offer, regardless of whether they're there or not, then they're not going to be included. So just know that that's a discussion you'll want to have with the seller when you're taking a listing, when you're doing the listing agreement. Okay. And then this is a pretty important change, technical change also, in case you have an issue with this. As far as unpairing or deleting data from smart devices, that the seller's obligation survives closing. So it gives the buyer some leverage there to be able to try and make the seller do something to in my mind, to finish conveying the property. Let's see, same change here, present on the day of the offer with respect to personal property. So just note that. We keep going down. We covered that. Okay, special assessments, buyer inspection. Now this is also a small one, but a big one, and it's going to probably take a little bit of getting used to, but hopefully once we do, it'll be okay. I'm sure all of you have experienced transactions where the buyer is abusing the delay payment of the due diligence fee, and it's led to all sorts of problems. So in order to curb this abuse by buyers and make things a little bit more fair to the sellers, that the buyer's right to terminate is contingent on the delivery of the due diligence fee. So if they haven't paid the due diligence fee and then they terminate, then that's going to trigger entitlement by the seller of the earnest money also. So just be aware of that. And as I would say, as a to your buyer agents, you're going to want to stress that if you've got a buyer agent, you're just going to want to make sure all your agents are on the same page. You don't want to recommend that a buyer terminate if they haven't paid the due diligence fee and then put their earnest money at risk also. So even if your buyer wants to do that, what you're going to want to do is make sure that your agents know to send an email to the buyer saying, do not do this without paying the due diligence fee, because you could be risking the earnest money also. And if the buyer wants to do it anyway and just dare the seller to go after them, fine. But you're going to want to make sure you have an email to that effect, in your file should things get sideways like that. There's been the next substantial change is in the representations about what kind of loan, how the buyer's going to purchase. It's simplified. It does have an extra option for USDA, for example, that got added in. So you could just have a checkbox for that. I mean, you could put in another also, but it was common enough where the forms committee decided to add that in there. But you can see second mortgage, other funds, and nothing about down payment assistance. And that was intentional because of the potential discriminatory effect by using that language in the contract. So now if they want to put, second mortgage, that's fine. But, just be aware that it's two check boxes, one for cash and then one for financing if this buyer wants to make those representations. And if they don't have to. It's not an absolutely essential part of the contract at all. If this whole thing is blank and the parties sign it anyway, then it's an enforceable contract anyway. It's really just to entice the seller to like the offer better, depending on what the buyer says the terms are. And there's a note here about, it says material changes with respect to funding the purchase of the property that affect the terms of the contract are material effects that must be disclosed. We get a lot of questions about this on the hotline, and our position is this. Again, I guess this is how I try to explain it. When the buyer signs the contract, their obligation is to buy the property. The seller's obligation is to sell the property. Okay, when it gets right down to it, to bare bones, that's what this is, right? The buyer buys, seller sells. And the method of payment for the buyer, generally speaking, is not material. It's just, it doesn't matter. Can the buyer make the deadlines and complete the transaction? That is it, really. But there are sometimes material changes. And I think a material change, the one that comes up the most often, is when someone puts down conventional and then they want to switch to FHA or VA. And I think there's plenty of times when buyers are doing this intentionally because most listing agents know that if you take on an FHA or VA loan, then, as far as what the appraiser tells you what the house is worth, subject to this, that, and the other repairs, along with the lender potentially making demands on seller repairs that they don't want to pay for, it just, those loans do come with, certain issues that some sellers don't want to deal with. So that's up to them. But it is material, and you can't get it done unless you have that form signed anyway. So then they send that form over afterward. And it's probably almost once a week where I have to explain to a listing agent or even a broker who's a seller who calls the hotline and you tell them they don't have to sign that form if they don't want to. So it's a decision the seller has to make. But as far as whether, if, let's say a buyer checks cash and then they go to a conventional, is that really material? I'm just not sure. I am not convinced of that as long as the buyer meets the other deadlines. But at the same time, I think as a listing agent, or not as a listing agent, as a buyer agent, you're going to have to weigh whether you think the license law is going to trigger a material fact or not, and base a transaction to transaction, just look at it. But if it is a big deal, and especially, I would put it, this is probably the best way to put it. The commission has said that it's always going to be a material fact if a party cannot complete the transaction. So I guess what I'd say is that if the change of funding is going to affect the party's ability to complete the transaction, then then that's going to be triggered and you're going to want to disclose that. So I think that's really the threshold, and I think that's really what the note is getting at. So I wouldn't read that to be more than what the license law says, but just so you know it's there and you can point it out to the parties. All right, this is the assessments again. We already went over that. Same thing here, assessments again, went over that. We're going to get to this a little bit later. Just note right here, this is a place where the seller or the buyer, for that matter, if they fill it out in the offer and get that information ahead of time, can put the information for the owners associations and dues in there. And for condos, that'll satisfy the Condominium Act's requirements as far as what the seller has to disclose, as long as it's in there. But we're going to talk more about the what it used to be called the condominium resale form, which is no longer called that. All right. There's not a substantial change in here. I think these are more technical edits in this, but just to know that there's been some adjustments to the language here for prorations and adjustments of taxes and rents. All right, this is another big change here. Probably the biggest change in this paragraph is actually we're going from 14 to 7 days. So just be aware of that. And if you need more time than that, then you're going to need to get a formal amendment done. Also, the amendment form has been changed so that if you change the settlement date in that checkbox under there, it'll be basically whether you're going to get 3 days or 7 days, as opposed to the 3 or 14 before. Okay. And there's been some changes to this, but if you read through it, it is still substantially the same as far as, if you're the delaying party, you're going to get a delay as long as you are, working in good faith towards settlement. Because the duty of good faith is implied in every paragraph, even though it's technically stricken like right here, you can see, right? But the law implies it in every contract anyway. So I think good faith is still part of it. And we get that question quite a bit, where a party is frankly not acting in good faith, especially buyers, who feel jilted and want to just hold up the seller, for one reason or another. If they're not acting in good faith, then they're not going to be entitled to the delay in settlement. But make sure that, before you, if you're in the seller side, terminate and then move on. You're going to want to make sure that you at least recommend that the seller seek legal advice, even if they choose not to, before they enter into another contract. That's required by the Code of Ethics. All right. So new paragraph 23, I'm not going to go into all the details of this. Just read through it. A lot of this is just going to be moved from other sections of the contract down here. And basically, if there's a breach by the buyer, then the seller should get the earnest money deposit and the due diligence fee, okay? And if there's a breach by the seller, the buyer can get the earnest money deposit and the due diligence fee with reasonable costs. And then attorney's fees, you can ask the court for them. Those are going to be discretionary. They're not automatic. So just, be aware of that. All right. Well, I'm not going quite as quickly as I wanted to, but the rest of the forms are a little bit simpler. So we'll move on. This one will be very brief. The Condominium Resale Act requires certain disclosures to be made by the seller. So, as I said, in 2T, you can do it there, and then it's done. You don't need this form or anything. But one of the questions we got was from this thing here, and I'm so glad they deleted this. We got this question constantly, whether this form was required in condo resales. And the answer was always no, because the residential property disclosure statement is required for condos. And this is the same stuff that's in the residential property disclosure statement. So there's no point in filling out the exact same stuff, what ended up being 3 times by the time you do 2T, the residential property disclosure statement, and the condo resale form. So this is not for condo resales. It's, for example, new construction, vacant lot or land. Okay, you can do it right there. And so you can do that and attach it to there, or if you're using 2T, you just put it in there. Okay, so just be aware of that. And then that takes us to now Form 101. that's where the next, there's not as many changes as there were in 2T, but there are some significant ones. And by the way, I'm just going to go back to this real quick. As you can see underneath the hyperlink here, it goes through paragraph by paragraph and explains pretty much everything I'm saying right now. So you don't have to memorize or take furious notes about what I'm saying here. I probably should have said that at the beginning. I guarantee there's somebody out there furiously taking notes trying to keep up with my voice, but sorry. I should have told you that ahead of time. Anyway, now you know. In any event, everything I'm talking about is right here and explains the reason why. And so, for instance, confusing legalistic language in the current version of paragraph 12 has been eliminated to make it more comprehensible. So now the committee is telling you why they decided to do something. Ones that we skipped, right? They're right here. One of the things that I didn't cover today is the backup contract addendum. They're technical changes, but you're going to want to be aware that they're in there. There are some in there as far as things getting moved around and the dates when things are due. So just know that that's there, okay? Let's see. The 4T, the amendment form, settlement date, right? And so the 7-day and versus 3-day thing is clarified there. And then that brings us down to Form 101. And so here you go. All right. And as you can see, compared to 2T, it's not, nearly as many, but there are some in there. So let's go through. The disclosure WWREAs, that's just a technical change there. If present on the day of the offer, same thing as 2T. Unpairing deleting devices, survive closing, so your seller knows that. Present on the property the day of the offer, same thing as 2T there. So one of the things that's changed, and this is in Form 101 as well as 201, so it's going to be in both agency agreements. But these buyer love letters, it is a warning about that and about fair housing issues to do that. So make sure your client understands that. Now, the reason this marketing section has been crossed out is because of clear cooperation that went into effect. The form has been edited to better harmonize with that rule. So what you got now is basically two options when it comes to marketing authorization. Your client will choose public marketing, which if you do public marketing, that'll trigger the 1-day rule under clear cooperation to get it into the MLS, right? Or office exclusive. And that's the other check down here. And it says at the top here, just to make it clear, marketing authorization, initial public marketing, or office exclusive, but not both, right? Okay. So just make sure your agents are aware of that and that they do it, okay? Also, just as a side note, we've been getting a lot of calls in the hotline with agents trying to get very creative to get around clear cooperation. I think it sort of highlights what an issue it was beforehand, the fact that they want to get around it so much, and also probably a reflection of the market. It's just one of those things where if the market is what it is right now, then probably we wouldn't be seeing as much of it. I remember it was the same thing back, just before the market crashed in 2008. You had all these people out there who thought that they could do without agents, and we saw what happened after that. It was a rough time for the industry, but I think at the same time, people suddenly understood how important it was to have an agent to get out there and really hustle in order to get a property either sold or bought. All right, and this is just a note about clear cooperation. But if you have agents in your office that are doing that, or if your office is trying to, I just had a hotline question this week where an agent was inserting language into the listing agreement, trying to basically alter the obligation of clear cooperation. But clear cooperation is not contractual. It's a rule. It's likely an MLS rule, so you could face some discipline or fines if you violate it. So if you have agents that are doing that, or if your firm's doing that, probably not a good idea. All right. Earnest money deposit this paragraph has been updated in the listing agreement just because a lot of firms, aren't doing earnest money deposits anymore. So this gives you some check boxes here and really sort of adjust the paragraph to reflect that new reality. Note the changes in here, especially on this part here, okay? And special assessments, okay? Fuel tank, there's a little bit of changes in here. And owners association stuff moved down here. I think that's it for this form. Oh, okay. Well, we might as well go into this paragraph here. We get a lot of questions on this particular paragraph. So your client can fire you whenever. It doesn't relieve their obligation to pay you because you have a contract. But if they don't want you to be the agent anymore, they can certainly tell you, to get lost and stop working for them. So what this does is it addresses that, and it always has, but it's been edited a little bit. So now it says, although seller may at any time withdraw from the fiduciary relationship existing between the seller and the firm, the contract created by this agreement may only be terminated by seller or firm prior to its expiration date by one, either a written agreement signed by seller firm, or two, legally sufficient cause. Now, I think these edits, they're meant to reflect what the form was trying to say before, but maybe inartfully. We've had a lot of internal discussion about this over the years, and I'm glad they finally changed it. But the biggest thing is that now you can either do a written agreement, or you can, if you got a difficult client, legally sufficient clause. And the biggest thing is, if you got a seller who's not cooperating with you at all, that is, you've got a contract to sell their property. That's what you're supposed to do. And so if they're not cooperating with you to make that happen, that would be a breach of the agreement. And depending on how serious the breach was by the seller, it would be legally sufficient cause for termination, but perhaps not termination with, you're still keeping entitlement to payment. Okay. Lastly, we're going to do Form 350T, okay? And there's not a huge change in this except this note at the top. We have written probably, I don't even know. We've probably written 5 Q&As about the forms, termination forms, because agents routinely send Form 390, which requires both parties to sign, and think that they've terminated the contract. I've already had a hotline question about it today. So in any event, there's a note here that talks about when to use this form compared to another form. And also another question we get constantly is, what happens if the seller doesn't sign? Nothing. The contract is certainly terminated. This is purely for the seller to release the earnest money. If they don't want to do it, that's their decision. In some instances it's warranted, some instances not. But in any event, now there's a note saying the seller to sign does not release the effect of the termination. So you can point that if you have a difficult buyer or seller and they need that explained in more detail, then now those notes in there are there to help you point that out to them and so make it more clear for them. All right. So that is all what I believe to be the most important forms changes. You can see here in Form 201, which is probably the only other form that's really most important to you guys. But you can see here, it's just not very much to that at all. They define protection periods, so you'll want to look at that. And also there's a new warning that has to do about fair housing problems with the love letters, like I went over the listing agreement, and also if there's a note added above paragraph 1 about just how to fill out the buyer, who the buyer is when the buyer is a corporation, LLC, trust, or other legal entity. Okay, I'm going to stop sharing, and maybe I'll share again at some point here if people have questions where I need to go back to the forms. But let's see in the chat here. I don't see any questions. Okay, Craig Fox says, the 60-day grace period does not apply to the new WWREA, correct? Yes, that is correct. That's already been out. The commission has already sent that out. Make sure you're using the new form. That's the only question I see in the box here. Does anybody else?
Smart group. There we go.
I hate to open the floor to them, but
Yeah.
I guess maybe we can.
Well, I think they would, I told them to put the questions in there. The only question I would have when we were talking about changing material facts about a loan or how you're going to pay for it, there's no real, if you disclose it, it isn't like the seller can terminate though. If you say, what you tend to see is someone says, I'm going to pay cash. And so that helps, that is a more powerful offer in this current market. And maybe they can even show that they have the funds to do it. And then they decide to get a loan because money's cheap. So they have to disclose it. But does the seller have any remedies, so to speak?
I find that to be an interesting question. And I guess the answer is going to be maybe on a case-by-case basis. And I'll tell you why.
Yeah.
A buyer has to make the offer in good faith, right? And they got to operate under good faith when they're in the contract, right? And there are definitely times where I've heard of situations where it doesn't seem like that's what the buyer's doing. So if the buyer has purposely made a misrepresentation in order to induce the seller to sign this contract, the seller most certainly would have some legal remedies to be able to get out of it. Proving it would be hard. And I think that's really where these claims really have issues, is just on the proof element. I think everyone knows that this is something buyers do. They're puffing in their offer to try and get the contract, especially in this market, right? So it's something that is happening, and all we can do is try and make sure the form does the best job it can while being fair to the parties. But the bottom line is this, is that if you've got an egregious situation, and sometimes I've seen them egregious enough to where the buyers left a pretty substantial evidentiary trail showing how silly they've been with the misrepresentation. So if you got something like that, that's just not brokerage. So if your seller's hot and mad and ready to set the world on fire because of a buyer doing this, then you just say, listen, you've potentially got some options, but you got to go talk to a lawyer to figure them out, because that's not something I can do unless in situationally, you can approach the buyer agent and say, listen, I'm about to tell my client to go get an attorney unless you accept X from my client to let my seller out now. But I wouldn't go too much further than that without making sure your seller had a lawyer to do the rest of it. So it's one of those interesting, gray areas between brokerage and law, because certainly, when it comes to, facilitating the execution of the contract as well as the termination, that's all included in brokerage. So you just got to make sure that you feel comfortable in that lane. And if it just gets even a little bit hot with respect to parties wanting to bring legal claims or whatever, then bow out as soon as possible.
Okay. Looks like we have a couple of questions now.
All right. No, that's Jessica says, I thought the contract is not contingent on a loan. That's still correct. It's not. The buyer still has an obligation to buy no matter what. And they don't get a right to terminate that is dependent on whether they get a loan or not. They got to terminate during the due diligence period. And Craig Fox says, do you know if the committee gave any thought to producing a standard appraisal addendum? No, I do not. I do not know if that's something they considered.
And I'm assuming he means like waiving any financial concessions.
Yeah. Well, I'll say this. I don't know if they considered it or not, but based on what we've already written on this, my answer would be very likely. Maybe if they discussed it, it was probably all of 5 minutes and they decided not to do it. Obviously, they didn't do it. But we've written several Q&As on the absurdity of these appraisal addendums. They are completely ineffectual and unenforceable. They are merely, in my estimation, from the dozens of them I've reviewed, they are merely, meaningless statements by the buyer that they'll buy the property no matter what an appraisal. But here's the thing: if it's attached to Form 2T, the buyer could terminate just because they don't. Hold on, my children are calling me. The buyer could terminate if they don't think the stove is clean enough. It's meaningless. These appraisal addendums are on the whole meaningless. Some of them attempt to put some real teeth into it, and I guess those maybe don't fall in the category of what I'm doing. But I'm just telling you, if you're a firm that's using one of those right now, chances are you have one that is purely illusory and doesn't have any real meaning or effect at all. And we've written a couple Q&As talking about this.
Well, it's kind of like another form of a buyer love letter. You're just, we really like it. We don't care what it appraises for.
Yeah.
At least it doesn't violate fair housing. So.
And then Gail Clare says, what form were you referring to regarding the disclosure of a loan instead of cash? I think, if I had to guess, that's in Form 2T under the buyer representations, where they're telling the seller whether they're going to do a cash purchase or whether they're going to seek a loan. That's the only form that I've spoken about today where it has that section in there. No, there's not a separate form. Any other questions?
Okay, I think we're good.
All right. Well, listen, I'm sorry I did not meet my goal. I definitely went over my goal, but at least got you guys the information you need to hopefully, don't commit, realtor suicide out there with respect to the new forms. So good luck. And if you need any further guidance, feel free to reach out to the hotline. We'll get you straightened out.
Really appreciate your time, John. Thanks a lot.